Summit organized by the Legal Aid and Awareness Committee at National Law University, Jodhpur. We extend our heartfelt gratitude to our Honorable Vice Chancellor, Professor Dr. Harpreet Kaur Ma'am, for her unwavering guidance. We also extend our gratitude to our esteemed Registrar, Ms. Sunita Pankaj Ma'am, for providing us with continuing support. National Law University, Jodhpur, established in the year 1999, stands as one of India's premier institutions for legal education and research. This year, we proudly celebrate 25 years of academic excellence guided by our motto, Knowledge is Empowerment. Our university fosters an environment that promotes intellectual growth, critical thinking, and a deep commitment to justice. Equally, we are recognized for our dedication to social justice and community engagement.
At the heart of many of these efforts is a Legal Aid and Awareness Committee, established as a formal committee in the year 2016, which embodies the university's vision of justice for all. The committee has been consistently working towards fostering legal empowerment, raising awareness, and providing vital assistance to the people in need. We have diversified into various fields of work, including but not limited to our Smart Village initiative, the Right to Education initiative, the Legal Aid initiative, and our Awareness initiative. आज की स्टेक होल्डर समिट हमारी कमेटी की लीगल अवेयरनेस और सोशल रिस्पॉन्सिबिलिटी के प्रति समर्पण से प्रेरित है। हमने इसका पहला एडिशन 5 अक्टूबर 2024 में किया था, जहां पर हमने किन्नरों के अधिकारों और नालसा जजमेंट के 10 साल पूरे होने पर एक महत्वपूर्ण अवसर को सेलिब्रेट किया था और उनके राइट्स के बारे में बात की थी। इसमें एक्सपर्ट्स, एक्टिविस्ट और अकेडमिशियंस ने मिलकर ट्रांसजेंडर पर्सन्स प्रोटेक्शन ऑफ राइट्स एक्ट 2019 पर वर्कशॉप भी ली है।
इसी सफर को आगे बढ़ाते हुए इस साल हम सेकेंड स्टेक होल्डर समिट ऑर्गेनाइज करवा रहे हैं और आज के एडिशन पे हमारा ध्यान जुवेनाइल जस्टिस पर केंद्रित है, क्योंकि हम जुवेनाइल जस्टिस केयर एंड प्रोटेक्शन ऑफ चिल्ड्रन एक्ट 2015 के 10 साल पूरे होने का अवसर मना रहे हैं। ये एक्ट बच्चों के अधिकारों के आंदोलन में एक महत्वपूर्ण कदम माना जाता है, क्योंकि इसने पनिशमेंट के बजाय रिहेबिलिटेशन यानी कि पुनर्वास और रेस्टोरेटिव जस्टिस पर ध्यान दिया, ताकि कानून के दायरे में आने वाले सभी बच्चों को दूसरा मौका मिल सके।
A key highlight of today's summit is the policy brief drafted by our committee members on probation. The draft addresses legal, structural, and institutional gaps in probation and rehabilitation within India's juvenile justice framework. With that, it is now my pleasure to invite our Dean of Academics, Professor Dr. Manoj Kumar Sir, to deliver the welcome address.
Good morning, everyone. It gives me a immense pleasure to welcome you all, and also the heartfelt gratitude to all my resource persons here who have given time from their busy schedules. And I can see that mix of the resource person which is representing the academia, the practitioners, and also the working on a ground with the United Nations team, and also the participants who has come across from the diverse background. So I welcome you all to this second edition of the Stakeholders Summit, which is organized by the LAAC, which is a legal aid awareness committee of NLUJ. This summit reflects our ongoing commitment to create spaces where the law students, practitioners, policymakers, and academics can come together and to exchange their ideas and also the work toward the justice that is both effective and humane. At NLUJ, the Legal Aid Committee has stood as an intersection of law and community. Our work extends beyond the classrooms and courtroom. It reaches the villages. It also reaches the schools, local institutions, through the different kind of legal awareness drives, legal aid clinics, and also the policy discussions at various stage, at various level. Whether it is conducting the classroom sessions, facilitating the right to education admissions in the schools, or supporting access to justice initiative, the Legal Aid Committee has consistently aimed to make the law a living reality for those who need it most. This stakeholder summit is an extension of that ethos, an effort of being meaningful legal discourse closer to the ground realities of the people's life. Last year we had launched our the flagship event with the summit, which was the first stakeholder summit on the transgender rights, which became a powerful platform for the dialogue on the inclusions, identity, and dignity within our legal system. And building upon that momentum, this year's theme turns to an equally urgent and humane concern, that is the juvenile justice. The year 2025 also marks a decade since enactment of JT Act 2015, a landmark legislation that redefined the state's responsibilities towards the children in conflict of law and those in need of care and protection. Over these 10 years, the Act has evolved from being a procedural statute to representing a moral vision of justice rooted in empathy and reintegration. It reminds us that justice for children must always be restorative, not retributive. That every child, regardless of circumstances, deserve the opportunity to reform, rebuild, and return to the society with dignity. Through this summit, we hope to reflect on these 10 years of the JT Act, its achievements, its gaps, and its future, and to discuss how strengthening the role of probation officers can bring us closer to the law's original vision of compassion and care of the children who are in conflict with law. I am glad to see such an engaged audience and a panel of distinguished expert speakers who bring a wealth of experience and perspective to this conversation. Let us look forward to a thoughtful and productive exchange of ideas that moves us closer to a more human, restorative, and responsive juvenile justice system for the children who are in conflict with laws. I hope this summit will give us invaluable ideas and whatever gaps are there to fill that gaps. So I welcome you all to this summit and I wish this summit to be grand successful. Thank you all.
Now we invite the faculty chairperson of the Legal Aid and Awareness Committee, Professor Dr. Anjali Khandri ma'am, who has been a constant source of mentorship and encouragement for us. Ma'am, we would please request you to come on the stage and address the gathering. Thank you very much. So, thank you once again. Good morning, Honorable Vice Chancellor Ma'am, Professor Dr. Harpreet Kaur, Dr. Sunita Pulkaiman, Registrar, National Law University. Even in their absentia, they have been a great support and inspiration for this entire summit, which we have organized today under the aegis of Legal Aid and Awareness, under the Legal Aid and Awareness Committee. Dr. Manoj Kumar Singh sir, Dean of Cabinets, Honorable guests, Mr. Muktesh Maheshwari sir, Dr. K.P. Asha ma'am, good evening ma'am, Dr. Purva Nigutkan ma'am, Dr. Rama Devi ma'am, Mr. Ashutosh sir, and Mr. Ajay Sharma, and Mr. Govind Binwal sir is online. So I welcome you all, good morning all, and my enthusiastic participants, my LAAC team, and volunteers, my dear students, and ladies and gentlemen. It gives me immense pleasure to welcome you all to the second edition of the Stakeholder Summit, organized by the Legal Aid and Awareness Committee of National Law University, Jodhpur. This summit represents our continued effort to bring together practitioners, policymakers, academicians, and students to engage in meaningful conversation about law, justice, and reform. Last year, we launched our flagship event with the Summit on Transgender Rights, which opened an important dialogue on inclusion and dignity within the legal system. This year, our focus turns to a theme equally significant
and deeply humane juvenile justice. India has world's largest youth population with approximately 30% of the total population, and youth are considered as asset in future of any country. They are the primary drivers of innovation, economic growth, and social change. Their energy is vital for nation building, but their potential can only be realized if they are provided with healthy environment to grow. It is a sad reality that today our country is witnessing sharp rise in the violent crime amongst the juvenile. In today's summit, our focus would be on bridging the gaps between the existence and the implementation of the JJ Act. More specifically, we turn our attention to the role of probation officer, whose work lies at the heart of ensuring that the system remains rehabilitative rather than punitive. Today's event is particularly special because it marks the initial launch of our policy brief on the role of the probation officer. This is a policy brief which is developed by our student at our university. I say initial because this is not a final document. We would require the inputs of our experts and the inputs of the participants also who are participating in this event. We have deliberately chosen to present it here before a gathering of stakeholders to invite their valuable insights and suggestions. The varied perspective will help us strengthen this document before it is formally presented to the policymaker and public. The policies brief represent months of collaborative research by our students. It maps the journey of a child through the juvenile justice framework, from early intervention and institutional care to transition planning and aftercare and analysis, how the probation officer acts as an essential bridge between legal structures and a child rehabilitation. It highlights key reforms across 4 areas. First, addressing procedural and statutory gaps that delay effective intervention. Second, reforming social investigation reports and individual care plans to make them data-driven and child-friendly, child-centered. Third, building capacity in mental health support for probation officers through specialized training and multidisciplinary network. And lastly, but not the least, strengthening aftercare and community reintegration through mechanisms like district aftercare panels, social reintegration funds, and mentorship networks. Through these recommendations, the brief envision a shift from a compliance-oriented juvenile justice system to one that is restorative, community-based, and child-focused. This event provides a crucial platform for discussing these challenges and exploring practical solutions. Our main objective is to generate actionable strategies to close policy gaps and strengthen the enforcement of juvenile justice mechanism. To all the participants and scholars gathered here today, I extend my deepest gratitude. Your engagement ensures that juvenile justice is not just a statute in a book, but a lived reality for every child who deserves care and a second chance. I also wish to commend the timeless efforts of the Legal Aid and Awareness Committee and our student volunteers, whose dedication continues to drive meaningful changes on the ground. As we engage in today's discussion, let us remember the real change stems from action. Every insight we share, every gap we identify must translate into a concrete step that moves us closer to a future where no child is denied the opportunity for rehabilitation, dignity, and hope. Justice for children is not only a legal goal, it is the foundation of a compassionate and equitable society. I would now welcome you all to join us for the summit with a quote by Ruth Bader Ginsburg. I quote, "Fight for the things that you care about, but do it in a way that will lead others to join us." Unquote. With this thought and expression and end expectation that I want that we all join together to fight with the gaps which are there in the implementation of the JJ Act. I once again welcome you all for this summit. and hope that we all learn together and we all strive together. Thank you once again.
Thank you so much, ma'am, for your meticulous insights about the policy brief. It is now my distinct privilege to invite our keynote speaker, Advocate Muktesh Maheshwari sir, to deliver the inaugural address. Sir is a distinguished practitioner in the Rajasthan High Court, Jodhpur, with over 15 years of accomplished litigation experience spanning criminal, civil, and corporate law. He brings unparalleled insight into the practical dimensions of juvenile justice. Apart from this, Sir serves as a guest faculty member at J. Narayan Vyas University, where he mentors aspiring legal professionals. We welcome you on stage, sir.
Thank you. Thanks a lot, first of all, to the organizing committee for inviting me here as a speaker and so also as a panelist. And so also, I'm so delighted to be a part of this event and more particularly the topic which has been chosen for the summit this year. Friends, हमें सबको पता है we are here for discussing the shortcomings, maybe the gaps which is in the juvenile justice or maybe the implementation. We see the Juvenile Justice Act which was enacted in the year 2015. उससे पहले there were previously the existing Juvenile Justice Acts too. The precise reason why this Juvenile Justice Act of 2015 was enacted, does anyone of us know why this amendment came into place? We all work at the ground level, we all work we all are from the distinct background, we work for the juvenile justice or maybe for the betterment of the juvenile side. Or maybe we want to. But सबसे बड़ा important बात है that why this Act of 2015 came into existence. Yes, somebody?
JS for committee.
Yes. Why that committee was formed?
In the aftermath of the Nirbhaya rape case.
Precisely. One of the most heinous crime that took place in the country, Nirbhaya case, in the year 2012. Justice Verma committee was formed. The reports were given. And then there was a major reforms and then the People's Act of 2015 came into existence. You know, the whole motto behind this act was, there were two mottos. Until now, we were working for the development and for the juveniles based upon one single thing. That was, and that's very important and goes till now. वो क्या है? That no child is born a criminal, and it is the society's fault that makes a child a criminal. So a child never fails a society. It's the society that fails a child. That was the first thing. But now, a very heinous crime took place in the year 2012. We all are aware. इसके बाद क्या हुआ? A very important, you know, and precisely why this act was required and why this committee was formed. One of the offender, जिसकी age थी around 17 years, took shelter of the fact, despite committing and being a part of such a heinous crime, that I am a juvenile. I must be treated like a juvenile. So, what was the major reform which took place in the year 2015 when ultimately this act was enacted? Does anyone have any idea about this?
So, the age of 16, 18.
Yes, precisely. So, the age of 16 to 18, this criteria was introduced, and the offences by the juvenile were categorized into three parts. One, puny or petty crimes, then serious and heinous. Right? So the precise reason for distinguishing these three types of crimes were that one cannot take shelter. Let's say somebody is above the age of 16 and somebody commits a very serious crime like what happened in the case of Nirbhaya. Can that person be allowed to go free just because the age is below the 18 years age? Below 18? No. So for that, we have now the mechanism in the Act of 2015. We have the moment some crime is committed, like let's say somebody is below the age of 18. The definition of juvenile is precisely below the age of 18 only. बट 16 to 18 की एज को हमने इस तरह से डिफाइन कर दिया है कि इसके अंदर if somebody is committing a very heinous crime, like what happened in this case, then we need to identify whether that person is mentally capable of being tried as a juvenile, or हमें उसे as a adult treat करना है. This was the precise reform and this was the precise reason why the entire act was introduced in the year 2015. Now, since I have been told that I have to mostly point out, and I have like the entire theme of this summit is the gap between implementation of this act, especially आप लोग जो ground level पे काम करते हैं आपको सबको पता होगा. This determination of age, juvenile की हमने क्या बना रखा है that 18 years of age, a person who is below the 18 years of age is to be treated as a juvenile, right? It's given in the act. There has been judgment of Honorable the Supreme Court that age determination का सबसे important aspect क्या है? What do we consider it to be the most important aspect of the age determination? Anyone? Matriculation or 10th certificate? Now, ये बात किसी से नहीं छुपी है. I'm not criticizing the aspect because that has been a very regular practice and that happens. We have to understand one thing. Actual India resides in the village, at the rural part, not in the urban, not in the city. And what's the practice out there? Age कैसे दिखाई जाती है? The matriculation certificate is based upon the school's age. I'll tell you, in this I'll tell you one of the experiences I had when I was a very young lawyer. Year 2000, I started my practice in the year 2008 or 2010-11 की बात है. I was like working with my senior and I happened to visit the Juvenile Justice Court at that point of time, and there was some juvenile who was presented before the court, and I was just watching the proceedings, and I saw a big hefty fellow of around maybe looking like somewhere in early 20s, a big grown-up beard and well-built, who was to be tried with under the Juvenile Justice Act. That was prior to coming of this 2015 Act. So I'm talking somewhere in 2011-12. And I was like, yeah, juvenile? And ultimately I asked like some of my seniors who were present there, how? They said, you see, the criteria for determining the age of a juvenile is not how the person is the matriculation certificate which one holds. It might be, that person might be a grown-up adult, but he was holding a matriculation certificate of maybe the age below the 18 years of age. Similarly, ये भी हो सकता है. There can be a vice versa situation. So what I was saying was that let's say somebody goes in the villages, जब किसी स्कूल में एडमिशन होता है, usually what happens is the parents take the children to the village, to the school. The age is asked, and unfortunately, it's not something to be, feel good about. But unfortunately, till date, ground level पे आप देखेंगे कई जनों का date of birth certificate नहीं बना हुआ. So ultimately, the school में headmaster relies upon his age which has been given by the mother, father, or anyone who has gone to the school for taking the admission. Now it's quite possible 5 या 6 साल 3-4 साल ऊपर नीचे करके एज लिखा रहे हैं, because it's not their fault. They actually don't remember the actual age or the date of birth when the person was born. So there cannot be a vice versa situation that the actual age of the person is, let's say, below the 18 years of age. और क्योंकि स्कूल में कुछ गलत लिखने पे आ गई, so the person was now treated to be an adult. So isn't it one of the biggest gaps in implementing the Juvenile Justice Act, because we strongly rely upon the matriculation certificate, uske aage we do not see anything. Secondly, I'll just give you one more example, like to just cut short. The Juvenile Justice Board, we all have heard about it. हमने ये Juvenile Justice Board क्यों बनाया? See, as अभी डीन सर ने बताया, मैम ने बताया that the Act, Juvenile Justice Act of 2015 is not a punitive act. It's a reformative act. Meaning thereby हमारा पर्पस ये नहीं है कि किसी बच्चे को पनिश ही करें.
हमारे को उसे सुधारना है, because he is a part of society who will be the future of the country at some point of time. So, for reformative action against the person, we don't want him or her to be tried as a regular criminal. So we have a very separate mechanism for their trials. वहाँ पे we have juvenile justice members, we have separate, we have next friends who assist the juvenile who are accused of some offense. Now, what is happening is that this is just like one of the observations what I usually see around. In juvenile justice boards also, ultimately the officers who are presiding over it are the trained judicial officers. You see, no one is at fault here. The problem is, once we give the entire, we are again talking about reformation, the reformative action. Once we give this reformation in the hands of a person who is already a trained judicial officer, primarily, whether it would be possible for such a trained officer to treat a juvenile as a juvenile and not as an offender. Suppose if the same person is dealing with a trial of, let's say, there can be a case जहाँ पे adults भी हैं और juvenile भी हैं. उसी case के अंदर the same officer is dealing to be a presiding officer of the juvenile justice board and the same person is sitting as the judge in the actual trial where some of the adults are involved. Whether it would be possible to treat the juvenile with the same view or with the same line of action as we were treating the other accused. So, of course, during the course of our panel discussions, we'll come across certain inputs, we'll come across certain ideas which can be implemented. I've just gone across the policy which has been provided to me right now. I was just going across till the time I was waiting, and wonderfully drafted, wonderfully, the points which have been precisely made in it, those are really wonderful. And over the course of time, when we'll discuss more about in the panel discussion and we'll have the ideas of all these distinguished panelists, I'm sure the few of the gaps what we usually see in implementation of the Juvenile Justice Act at the legal or the ground level, शायद हम उसको meet out करने की कोशिश कर पाएंगे. And once again, thanks a lot to the entire team, to the entire committee which has planned and taken up this wonderful topic, which is usually not touched. I've seen a lot of seminars, a lot of summits, but a topic like this really deserves a serious discussion. Thank you, thanks a lot, and I'll be looking forward for this panel discussion, and I hope I'll take something more out of it. Thanks a lot.
Giving us all an overview of the JJ Act. It was indeed an eye-opening address. We now invite our Dean of Academics, Professor Dr. Manoj Sir, to felicitate Muktesh sir. So please come on the stage. Member at the School of Social Work, Tata Institute of Social Sciences. With 30 years in child protection, her doctoral research focused on rehabilitation of children in conflict with loss. A former Juvenile Justice Board member, she led the team that drafted the model SOP on missing children. Subsequently,
who is a member of the Child Welfare Committee, Rangareddy District, Telangana, and former faculty in ICFAI Law School, Hyderabad. Her
who's a senior manager Rajasthan at Prayas JAC Society. With 15 years in child protection, he specializes in marginalized children. We welcome you, sir.
who brings over 20 years of experience in rights-based social legal work, focusing on child rights, gender justice, and legal empowerment. He has worked with UNDP, CRY, and Partners for Law and Development and currently serves as State Consultant, Child Protection, UNICEF, Rajasthan. We welcome you, sir.
justice expert with over 18 years of experience across government bodies, NGOs, and UNICEF, Services Authority, and the State Commission for Protection of Child Rights. We warmly welcome you all to the National Law University, Jodhpur.
With this, we mark the end of the inaugural session. Now we transition to our first session today, which is a policy dialogue on probation and rehabilitation, the legal, structural, and institutional gaps. We are privileged to host a distinguished panel of academicians, legal practitioners, policy experts, and field specialists. This session serves not only as a merely scholarly exchange, but as a critical platform to examine our committee's policy brief, refine its recommendations, and advance systemic reform in juvenile probation mechanism. We anticipate a rigorous dialogue that bridges theory, implementation, and practice.
I would request our panelists, Asha ma'am, Mohua ma'am, Rama ma'am, Muktesh sir, and Ajay sir, to please come on the stage and have a seat.
I'm extremely delighted to moderate the session 1 of today's Stakeholder Summit. The topic of today's discussion is policy dialogue on probation and rehabilitation, legal, structural, and institutional gaps. A probation officer's basic role in Indian juvenile justice system is to investigate the child's background and social circumstances, supervise their rehabilitation and social reintegration, and report their progress to the Juvenile Justice Board. Across states, there is no uniform standard or training requirement for probation officers. Many are drawn from administrative backgrounds with limited exposure to social work, psychology, or child rights. This often results in delayed or generic social investigation reports, inadequate individual care plans, and little structured follow-up after release. The absence of coordination between probation and aftercare means that children frequently leave institutional care without meaningful support, only to find themselves re-entering cycles of vulnerability and conflict with the law. Today's discussion builds on a policy draft prepared by the Legal Aid and Awareness Committee on Probation, and we are joined by distinguished speakers who bring academic, legal, and field perspectives to this issue. Through this intervention, we hope to identify both the visible and invisible failures within the current system and collectively reimagine our pathways towards more effective and humane rehabilitation. Our dialogue today revolves around 5 interconnected themes. Firstly, institutional versus non-institutional rehabilitation approaches. Secondly, the role of probation officers and social investigation reports. Thirdly, education, skill development, and vocational training for juveniles. Fourthly, measuring the success of rehabilitation. And last, legal representation and access to justice for children in conflict with the law. Together, these themes invite us to move beyond punitive structures and instead question whether our current framework truly creates opportunities for reintegration, dignity, and growth. To open the conversation, I'd like to invite Dr. Mawa Ma'am to share her insights on institutional versus non-institutional rehabilitation approaches and how the balance between care, accountability, and community-based interventions can shape the future of juvenile justice system.
Manoj Kumar, Dean Academics, convener of the Legal Aid and Awareness Committee, Professor Dr. Anjali, the Student Organizing Committee, and all of the participants who are here today. Thank you for this opportunity. और बहुत साल पहले, nearly 30 years back, जब मैंने मास्टर्स इन सोशल वर्क किया था, तभी मेरा पहला जो जॉब था वो was a probation officer. तो वो जो एक्सपीरियंस था कि एज अ प्रोबेशन ऑफिसर हम कितने गहराई से बच्चों का जो स्थिति है जो सिचुएशन है, जो सर्कमस्टेंसेस है, वो समझ ले और उसके आधारित हम रिपोर्ट्स बनाएं, ताकि जो जुवेनाइल जस्टिस सिस्टम का जो ओवरऑल गोल है, रिहैबिलिटेशन और सोशल रीइंटीग्रेशन, वो किस तरह और बेहतर कर सके। बहुत साल बाद इन दैट सेम ऑब्जर्वेशन होम जहाँ मैंने करियर शुरू किया था एज अ प्रोबेशन ऑफिसर, आई वेंट बैक देयर एज अ मेंबर ऑफ द जुवेनाइल जस्टिस बोर्ड इन 2007। तो मेरा जो तजुर्बा है, एंड ऑफ कोर्स आई एम टीचिंग इन TISS सिंस 2000, मेरा जो तजुर्बा है जुवेनाइल जस्टिस सिस्टम को लेकर, चिल्ड्रन इन कॉन्फ्लिक्ट विथ लॉ को लेकर, एज अ फॉर्मर सेवरल इयर्स बैक प्रोबेशन ऑफिसर, उन दिनों जुवेनाइल जस्टिस एक्ट 1986 हुआ करती थी, फिर 2000 आया, एंड नाउ वी हैव द 2015 एक्ट, member of the Juvenile Justice Board, Mumbai Suburban for 7 years, and of course our students, teaching, fieldwork. मेरा जो भी slides है, this is a culmination of all of those experiences. Please tell me when I'm out of time. Yeah, we go to the next slide. तो आज का जो टॉपिक है, मुझे जो टॉपिक दिया गया, वो है रिहैबिलिटेशन एंड सोशल रीइंटीग्रेशन। लेकिन ये ना इंस्टीट्यूशनल वर्सेस नॉन इंस्टीट्यूशनल अप्रोचेस नहीं है, ये इंस्टीट्यूशनल एंड नॉन इंस्टीट्यूशनल अप्रोच है, क्योंकि हर एक बच्चे का संदर्भ अलग है, ज़रूरतें अलग है और रिक्वायरमेंट्स अलग है। तो कोई भी एक हम स्टैंडर्डाइज टेम्पलेट नहीं कर सकेंगे। स्टैंडर्डाइजेशन इज इम्पॉर्टेंट कि ये सारे प्रावधान हैं, ये सारे रिहैबिलिटेटिव मेजर्स हैं, लेकिन कौन से बच्चे को क्या रेलेवेंट है, उस बच्चे का कॉन्टेक्स्ट ही हमें ज़्यादा जानकारी देती है। जुवेनाइल जस्टिस सिस्टम जो है, जुवेनाइल क्राइम, ये बहुत ही सीरियस टॉपिक है और बहुत ही कॉम्प्लेक्स टॉपिक है। जुवेनाइल क्राइम बेनिफिट्स नो वन। विक्टिम है, हार्म एंड इंजरी है, शायद लॉस ऑफ प्रॉपर्टी है, अदर काइंड्स ऑफ लॉसेस है, ऑब्वियसली naturally it does not benefit the victim. Juvenile crime does not benefit the child in conflict with law. वही लड़का, और मैं लड़का बोल रही हूँ क्योंकि the number of girl juveniles in conflict with law are less. Nonetheless, they require an additional attention because there is a gender context when it is a girl juvenile in conflict with law. But for now, there are many more boy juveniles in conflict with law, child in conflict with law. It does not benefit that child. Instead of going to a school, instead of going to a college, instead of planning higher education, instead of thinking कि मैं आगे जाके क्या करने वाला हूँ, क्या बनने वाला हूँ, क्या बनने वाली हूँ, we are discussing police station, we are discussing bail, we are discussing observation home, we are discussing lawyer and free legal aid, and we are discussing ये system से मैं कब निकलूँगा. So the whole milieu, the whole thinking of the child changes with that one act or acts of offenses. Juvenile crime definitely does not benefit society, because instead of having productive, constructive, happy adults who will contribute to society and be happy and contented with their lives, we are losing out on this youth potential. So juvenile crime really does not benefit anybody. And as our guest speaker rightly said, advocate said rightly that society has somewhere also failed these children. So when you look at the history of the juvenile justice system, 2015 is the current act. But this system has started 100 years back. क्योंकि उन दिनों ये जो first juvenile court आया था US में, then UK, then British laws came to India, the whole understanding was that the crime is serious, but the way we look at children or young people who have not completed 18 years of age, there will be a difference. And that is why over all of these years, both in India and globally, juvenile justice system is distinct from the criminal justice system. क्योंकि crime वही है, लेकिन हम किस तरह से approach करेंगे, और वही आ जाता है rehabilitation and social reintegration. अगर आप ये system देखते हो, बहुत सारे पहलू हैं, तो हम कोई भी एक चीज, जब हम reformation की बात करते हैं, strengthening the system की बात करके, enhancing the system की बात करते हैं, तो कोई भी एक चीज को हम isolation में नहीं देख पाएंगे. अगर आप ये integrated एक system देखते हो, a juvenile justice system, यहाँ बहुत सारे सब कंपोनेंट्स हैं, बहुत सारे सब सब सिस्टम्स हैं। तो अगर हम एनहेंसमेंट की बात करते हैं ऑफ जुवेनाइल जस्टिस सिस्टम, तो एनहेंसमेंट्स बहुत सारे जगह आना पड़ेगा। And a lot of progress has happened in India over several years of concerted efforts on strengthening the juvenile justice system. Okay? So I am not going into great details of this. This is just to tell us कि जब हम rehabilitation या social reintegration की बात करते हैं या strengthening of system की बात करते हैं, strengthening बहुत सारे subsystems में भी जरूरत है। एक 2015 में जो मैं मैडम प्रोफेसर अंजलि को भी बता रही थी यहाँ सेशन शुरू होने से पहले, एक 2015-16 में नेशनल कमीशन फॉर प्रोटेक्शन ऑफ चाइल्ड राइट्स एंड TISS हमने एक स्टडी किया था कोइंसिडेंटली राजस्थान और महाराष्ट्र को लेकर। और मैम अंजलि को मैं बता रही थी कि इतने साल 10 साल बाद आई एम बैक हियर टू डिस्कस दैट टॉपिक। तो तभी 3 स्टेट्स राजस्थान के आइडेंटिफाइड हुआ था फॉर विद सम क्राइटेरिया ऑफ कोर्स, and 3 cities in Rajasthan and 3 cities in Maharashtra. So Jodhpur, Jaipur, Kota, and in Maharashtra it was Mumbai, Pune and Nagpur. और तभी जो फाइंडिंग्स था स्टडी का, ये 2015-16 का स्लाइड है। अगर आप ये स्लाइड को 2025 में देखोगे तो शायद आप साइबर क्राइम, ऑनलाइन मीडिया, इम्पैक्ट ऑफ सोशल मीडिया, ये सारी चीज़ें आप ऐड करो। उन दिनों जो स्टडी हुआ था तो ये हमें समझ मिली अक्रॉस दिस 6 cities ऑफ महाराष्ट्र 3 एंड राजस्थान 3 कि बहुत सारे फैक्टर्स है बच्चे क्यों ऑफेंसेस में आ जाते हैं। देयर इज नो वन सिंगल कॉज एंड देयर इज नो वन सिंगल फैक्टर, इट इज अ कॉम्बिनेशन ऑफ फैक्टर्स। व्हेन अ चाइल्ड इज डूइंग वेल, यहाँ बच्चा और बचपन बहुत इंपॉर्टेंट हो जाता है। When a child is doing well, okay, doing well in school, doing well in studies, doing well extracurricular, is happy, is contented, has reached a certain benchmark of, let's say, achievement, success, I'm putting them in inverted commas, we will say it is a accumulation of experiences. Something positive has happened in that child's life. Maybe the family, maybe the school, maybe the friends, maybe the child's own hard work, maybe the child's coping capacities, the child's resilience. So many things come together to shape an individual's life. Now the same situation, when a child is not thriving, when a child is not doing well, when a child has become a child in conflict with law, of course the choice of that behavior, the responsibility of that behavior is with that child. But would we say it is alone a problem of that child, an individual problem of that individual child? I would disagree. It would again be a combination of factors. Is something going well with the family? Is something going well in the school? What about the child's peers? Has the child inadvertently gotten into addiction? So different situations create pathways to offense. और जब हम रिहैबिलिटेशन और सोशल इंटीग्रेशन की बात करते हैं, ये सारे सिचुएशंस, ये सारे सर्कमस्टेंसेस बहुत इंपॉर्टेंट हो जाते हैं ये समझना कि कैसे हम वो रिहैबिलिटेशन या सोशल रिइंटीग्रेशन को रेलेवेंट बना सके उस बच्चे के लिए। अभी चाइल्ड इन कॉन्टेक्स्ट, जब हम रिहैबिलिटेशन या सोशल रिइंटीग्रेशन की बात करते हैं, चाइल्डहुड एक्सपीरियंसेस, फैक्टर्स फॉर ऑफेंस, द ऑफेंस चार्ज, बच्चा अकेला था, फ्रेंड्स के साथ था, बच्चा एडिक्शन में है एंड टू फुलफिल दोस इंक्रीजिंग नीड्स, क्योंकि डी एडिक्शन ट्रीटमेंट शायद कई कारणों से शुरू नहीं हुआ है, is the child into offense? Is the child into a situation which created a situation of offense? So there are many reasons why the child gets into a situation of offense. And juvenile justice system's position is it neither excuses offense nor does it condone offense. बहुत बार ये क्रिटिक आता है जे सिस्टम को लेकर कि हम बहुत फ्लेक्सिबल हैं, हम बहुत लीनियंट है, we adapt to the needs of the child. The system is not flexible in that sense that anything will go just because this is a young person who has not completed 18 years of age or was less than 18 at the time of allegedly committing the offense. The system recognizes that young persons require a certain support, require a certain direction in their life. In my own experience as a probation officer, as a former probation officer, former juvenile justice board member, and working with students who are doing their fieldwork in observation home, many of these children lack a direction in their lives. See, all of us seated here in this room, maybe we don't like a routine in our lives. Maybe we don't like doing things every day, the same thing over and over again. But routine gives us a structure. Routine gives us a purpose. We get a direction. Children and all of us also, college students here, those of us who are working, we love to go on vacation and we love to relax and de-stress. But after a while, we do start thinking about, the core purpose. We may be a student, we may be a working professional, and many of these children, they lack that routine. They lack that purpose. They lack that structure in their lives. कि आगे क्या करना है? आज आपने ये प्लान किया, कल का प्लान क्या था? कितने प्लान्स फुलफिल्ड हुए? आगे क्या करना है? The other point is adolescent and youth focused work. ये बहुत important है जुवेनाइल जस्टिस सिस्टम को लेकर. अगर आप नेशनल क्राइम रिकॉर्ड्स ब्यूरो का डेटा भी देखते हो, आप देखोगे a majority of the children are in the age group of 16 to 18 years. And there are reasons why a large group of children would be between 16 and 18 years of age. अगर आप statistics को analyze करोगे, आप देखोगे बहुत सारे बच्चे theft cases में हैं, cases related to property में. तो किस तरह कस्टमाइज करेंगे, किस तरह डिजाइन करेंगे रिहैबिलिटेशन को लेकर कि जो बच्चा एक थेफ्ट केस में आया है, शायद अकेला है, शायद ग्रुप में है, हम किस तरह से उस बच्चे का करेक्शनल काउंसलिंग शायद करना पड़ेगा, इंटरवेंशन शायद करना पड़ेगा. कम्युनिटी सर्विस सेक्शन 18 ऑफ द जुवेनाइल जस्टिस एक्ट बहुत सारे ऑप्शंस देते हैं जुवेनाइल जस्टिस बोर्ड मेंबर्स एंड प्रिंसिपल मैजिस्ट्रेट को कि किस तरह से हम रिहैबिलिटेशन एंड सोशल रीइंटीग्रेशन करते हैं. जब हम इंस्टीट्यूशनल और नॉन इंस्टीट्यूशनल मेजर्स की बात करते हैं, ऑब्जर्वेशन होम, स्पेशल होम, प्लेस ऑफ सेफ्टी, all of them have a certain purpose and they would not be relevant for each and every child. Just as aftercare, just as sponsorship, just as other non-institutional measures may not be relevant for each and every child. So the point is, what is relevant for each child would play a greater role in rehabilitation. This is my last slide and I will end here. 2025 में एनफोल्ड प्रोएक्टिव हेल्थ ट्रस्ट ने एक स्टडी किया है रिहैबिलिटेशन और सोशल रीइंटीग्रेशन को लेकर. ये स्टडी था चाइल्ड इन नीड ऑफ केयर एंड प्रोटेक्शन को लेकर, और ये स्टडी था जो विमेन आते हैं शेल्टर होम्स में उनको लेकर. ये स्टडी चाइल्ड इन कॉन्फ्लिक्ट विथ लॉ को लेकर नहीं था. लेकिन फिर भी मैं ये स्लाइड क्यों लाई हूँ उनका स्टडी को लेकर, उनका स्टडी से कि अगर हम एक कॉम्प्रिहेंसिव रिहैबिलिटेशन की बात करते हैं तो यहाँ बहुत सारी चीजें आपको स्लाइड में दिखेंगे विच आर इक्वली रेलेवेंट फॉर चाइल्ड इन कॉन्फ्लिक्ट विथ लॉ. बहुत सारे ये जो बच्चे हैं चिल्ड्रन इन कॉन्फ्लिक्ट विथ लॉ, उनके फैमिलीज में बहुत बार स्थिरता नहीं है, स्टेबिलिटी नहीं है, ट्रस्टिंग रिलेशनशिप्स नहीं है. अगर हमको आगे जाना है, इफ वी नीड टू प्रोग्रेस, we do require a certain stability in our lives. We do require a certain stability in our relationships. तो जब हम rehabilitation और reintegration की बात करते हैं तो stability, trusting relationships, individualized support, follow-up mechanisms, बच्चे का daily routine. जब मैं juvenile justice board में member थी, last 2 minutes and I will close. जब मैं juvenile justice board में member थी, one thing we would ask every child, any child who came before the Juvenile Justice Board, we would ask one question. आप सुबह से लेकर, from the time you have woken up till the time you have gone to bed, what has been your daily routine? What have you been doing through the day? It gave us a lot of clues and a lot of insights into the child's life, and then how do we plug those unmet needs? What is the way forward? This is my last slide. जब हम रिहैबिलिटेशन और सोशल रीइंटीग्रेशन की बात करते, our own individual position on children who are in conflict with law also has an implication on our approach, our attitude towards system, adult approach towards these children who may not be thriving as well as adult children. So our own position, values, goals of rehabilitation has a huge implication on how we strengthen the system. Three things from my own experience I find very beneficial. ध्यान देना है, attention, support and direction. Individualized and intensive approach depending upon each child's need and circumstances. Social investigation report, individual care plans become a very, very important component of the juvenile justice system. The last 2 points, संदर्भ बच्चे का बहुत important रहता है. Family context in child vulnerability. 1940 में one of the earliest studies on juvenile crime, Doraisamy then Madras, today Chennai, the findings he had done a study with 100 children who were into different situations on crime. One of the critical findings was the family context. From 1940 to 2025, several studies have happened in the Indian context and globally on juvenile crime, on offense charges, and you will find one of the critical factors is the family context. So working with the family becomes very, very critical when we are working in this area. The last point, standards of care. Juvenile Justice Act, Juvenile Justice Rules, Guidelines, they all speak about different mandated standards of care. There is a quantitative aspect, there is a qualitative aspect. The quantitative aspect is what all needs to be done. What are the mandates of the Act? What are the mandates of the rules? Alongside that, the qualitative aspects. How are we doing? How are we communicating with the child? Are we trained enough? Do capacity building programs that we need to have. So for juvenile justice system to strengthen, as I am repeating myself, a lot of progress has happened. We need a whole lot of discussions, deliberations and further work in this area so that we ensure that every child who comes within the juvenile justice system as a child in need of care and protection, as a child in conflict with law, they go out as productive citizens, happy adults and contributing adults. Thank you so much.